This meeting to order. Clerk, would you please take the roll? Report the roll, please.
You have a quorum, Mr. Chair.
Thank you. Okay, as a preliminary matter, we've got three bills. House Bill 239, Delegate Kilgore, which was identical to Senator Chafin's 375. House Bill 751, Delegate Leftwich's bill, which is identical to Senate Bill 984. House Bill 987, Delegate Gilbert's bill, which is identical to Senate Bill 567. All of these bills passed this committee and the Senate unanimously. And if you all are inclined, we could have a motion to take those up in the block.
I move to take them up as a block, Mr. Chair.
Motion properly seconded to report those bills in a block. Clerk, please open the roll. Report the roll.
12 ayes, 0 nays.
Thank you. Delegate Ware, you had a similar bill, but we want to keep yours the same, right?
Yes, sir,
All
Mr.
right.
Chairman.
Tell us about that just briefly.
Very briefly, it is very similar to Senator Dance's bill. Mine would authorize the Secretary of Natural Resources to enter or negotiate a memorandum of understanding to transfer the Commonwealth's easement interests in battlefield lands that are located within the boundaries of federal battlefield lands. That's the gist
Okay.
of it.
And just for the committee's information, Senator Dance had the same bill, not exactly identical, but I think they've determined that Delegate Ware's bill is a better version, so we don't want to conform it. But if there's a motion to report the bill as is, the second, motion properly seconded to report that bill as is, please open the roll. Thank you, Delegate Ware.
Thank you, Mr. Chairman. Members.
11 ayes, 0 nays.
The sign-up sheet, Delegate Orrick. How are you?
I'm fine, thank you, Mr. Chairman. Hope you and the whole committee are. I've got three on your docket. May we take House Bill 865 first, please, sir?
House Bill 865.
Mr. Chairman, members of the committee, what this measure will do is give local governments the authority to effect an ordinance requiring a cash bond if pet shops in their jurisdictions are dealing with out-of-state breeding facilities. And it draws criteria as it relates to how many animals that they sell from these facilities. It will have zero impact or any kind of bonding requirement if they are selling from in-state sources, from in-state breeders. The rationale behind this, Mr. Chairman, members of the committee, we have authority over in-state breeding facilities, and if we have some sick animals, we can reach out. If they're out of state with no nexus, then what ends up happening is the local government, if the business goes belly up or it's otherwise has to be closed down, the local government has to deal with the cost of taking care of these animals. And this is purely permissible on the part of local government if they want to affect it and require a bond. There is one minor technical amendment, Mr. Chairman, we've noticed as the bill has gone through on the end of line 14, if we could strike the word 50 and insert the word 51. Because when we drafted it, we said, well, if you got up to 50, and then if you got over 50, well, 50, so that 50 you didn't have anything, I guess. So,
All right, is there a motion, make that amendment, motion properly seconded to amend that from striking 50 and adding 51? Motion properly seconded. All in favor, please say aye. Nays, the ayes have it. All right,
there
any
any questions,
questions
Mr.
of
Chairman?
Delegate Orrick?
Yeah, Mr. Chairman?
Senator Evans.
Yeah, Delegate, you mentioned what happens to pets from outside the Commonwealth. What happens if you have a pet shop that goes out of business and you had pets procured from inside the Commonwealth? How do the people who gave them to
we then would potentially have some recourse against the breeding facility that was located in the Commonwealth because we would have legal standing and authority over them. Virginia has a pet lemon law, as it were, where that if that doesn't attach to the pet shop, it could then also transfer back to the breeding facility so that the owner could be held harmless in their purchase price.
And just to follow up,
Senator Evans.
and that's more than just pet shops that go out of business, it's pets that are
For the lemon law, that applies in any circumstance where you have a sick animal that you get from a pet shop. You can take it back and either get your money back get another pet and replace things of that nature. This doesn't impact that.
Mr. Chair,
Senator Peters.
what is, Delegate Oric, what is the purpose of the bond? I mean, typically you
That is
post a bond.
spelled out in 19, that if the pet shop ceases business, the locality shall have the right to call the bond and utilize the resulting funds as reasonably necessary to protect the welfare of the animals from that pet shop. They can't sweep that bond in and use it for other animal control purposes. It has to tie to the animals that came from that defunct pet shop. There
Okay.
also is a caveat whereby I would also add, local government may waive, if a pet shop's been in business for 10 years already and no problems, they can craft an ordinance where they wouldn't have to come under this anyway. So we're not trying to go after any of the good actors,
Right.
but just giving local government a few additional tools if they feel necessary. We've had some circumstances this is brought forth because there were a couple local governments that got caught with significant cost of having to clean up an operation when one or two of these went out.
Does that satisfy you?
Sure.
It's hard to satisfy Senator Peterson, quite frankly. Senator Black.
Unless there's something else, I'd just move to report.
Let me just ask real quick, Senator Black, is there anybody who opposes this measure? Your motion is in order, Senator Black, if you'd like to make it now.
Yes, move to report.
Motion properly seconded to report the bill. I'm sorry, clerk, please open the roll.
12 ayes, 0 nays.
Thank you. Which one would you like
Thank
to
you, Mr.
take
Chairman. Maybe we
next?
take up 877 because that one is also related to pet shops.
House Bill 877.
And, Mr. Chairman, so that we're in the proper posture on that one, I do have an amendment. If staff could report that, I'd appreciate it.
Okay, could you all report that amendment?
Mr. Chairman, there are two amendments. The first one starts on line 234, as the bill is engrossed. After the word notice, strike the remainder of line 234 and through the word available on line 235,
Okay,
and simply insert a comma there. And then the second line amendment is on, at the beginning of line 237, strike the remainder of line 237 through the word office and insert the words subdivisions B5, 6, and 7 to the local animal control officer upon request.
And, Mr. Chairman, members of the committee, if I may, to explain the rationale. When we had it in the House, we thought we wanted the state vet's office to get this information as a matter of routine practice. They then came to me and said that would have certain fiscal implications. So what we're doing with this amendment is taking those fiscal implications out, where that the consumer will have the right to these records upon request, and we are adding local animal control officers similarly will be able to get this information without having to get a subpoena to secure it, just upon request.
so your Delegate Ork, your intent was to remove the fiscal.
That is correct, and it's my understanding and discussions
I'm not
with
sure-
the state
I'm not
vet.
sure the Senate Finance Committee agrees with you.
Well, I understand, but the state vet told me if they weren't in the equation, but I understand.
Well, my orders are that.
I
if this
understand.
bill
This probably
reports,
will
it
need to
has
go
to
up.
finance. That's right.
Understand.
There's a motion on the amendment second. Motion properly seconded to amend it as reported. All in favor, please say aye. Aye. Opposed, no. The ayes have it.
And understand, Mr. Chairman, it's trust but verify. They want to verify that I took them out. I understand.
All right.
So,
All right. Any questions of Delegate Ork on this bill?
and there are some people who would like to speak in favor of it, I believe.
Okay. Those who would like to speak in favor, please come on up.
Mr. Chairman and committee members, thank you for your time. I'm Kara Moran with Virginia Positivity Initiative. Purebred dogs are often superior in many ways. Health-tested sires and dams are selectively bred for improved breed soundness and additional genetic testing. It further reduces the number of preventable genetic diseases. Breed clubs also work to maintain predictable temperament and assist buyers with finding good breeders who do a better job of informing the buyers what to expect with their specific breed. Typically, a responsible breeder produces a better socialized puppy that is easier to train because from birth, their puppies have been handled and socialized so that daily interactions don't trigger unnatural fear and problematic behavior. Responsible breeders care for their puppies from conception by supplying better quality nutrition, qualified medical attention, and daily exercise. If that's what you think is happening in some of Virginia's pet stores, please reconsider. Everyone has the right to make their own choices, but is it really a choice when you are presented with misinformation, devoid of facts, and do not have any verifiable documentation regarding the authenticity and health concerning the pet you are purchasing? Currently, the pet store papers that are given to consumers do not include any conditions these animals are raised in or recent commercial breeding facility inspections or infractions. Virginia consumers deserve the right to verify information about the pets they are buying and, more importantly, what challenges they may have, what they may encounter behaviorally, fiscally, and emotionally when purchasing a puppy bred by an irresponsible breeder from a pet store. The proof is overwhelming as to what some of our pet stores are really doing. So why doesn't Virginia have full disclosure laws regarding pet stores? I want to thank Delegate Orrock for sponsoring this important bill because we as consumers need access to inspection reports to make educated decisions so we can be truly informed and make an informed choice. Thank
Okay,
you.
thank you. And Delegate Orrick, I always announce this, and I didn't announce it today, but we do run a timer, yes, sir, in here, and just because we've got 30 bills
They should
today,
be
I believe.
identified and
But I would
supported.
love for you to step up and tell us who you are and if you support this bill.
Thank you, Mr. Chairman. I am Heidi Meiser with the Virginia Federation of Humane Societies. We also support this bill.
Thank you.
Thank you.
Senator Ruff, could I just quickly ask if there's anybody who's in opposition to this? And we'll allow the same courtesy.
Good afternoon, everybody. Thank you for taking the time. I do agree with a lot what the senator has to say, but really my only fear as a pet shop owner, I represent Petland in Fairfax, Virginia, if there's going to be any overreach. And really this is what's going to happen because a lot of this information is already available through the travel certificate. This is just another way to get further into what we do on a daily basis by. She said that they purchase animals. They don't purchase any animals. So again, it's overreach in my opinion. I'm all about keeping things right, open, professional, legal, but local jurisdiction has already proven in the past to be biased. And so I'm having a hard time agreeing. I don't disagree with the information being shared, but who's sharing it and what way they're going about doing it. So I believe we already have enough in place. But.
Okay, you oppose the bill?
50-50.
Not really, okay. You're
I'm
ambivalent.
opposing on the
Okay.
side of that there's already something on the books that provide this information. Why do we need another place to have it again?
All right, thank you.
Thank you.
There's no one else who'd like to speak. There's a motion properly seconded to report the bill and re-refer to Senate Finance. Clerk, please open the roll. You want to report that, Chad?
Yeah, let's see, 15. 12 ayes, 0 nays.
We're still waiting for people to vote, delegates.
It's okay.
Okay, if the machine. Let me try it this way. If there's anybody who did not vote aye, please register your no now. I believe that was unanimous there.
All right. Thank you, Mr. Chairman, members of the
Delegate
committee.
Orrick, you just pause
Sure.
1 minute? I see Delegate Boysko in the crowd, and I neglected to mention that the Chairman of Commerce and Labor asked that House Bill 1087 be re-referred to the Committee on Commerce and Labor in the Senate. That happens over here from time to time. So if we could get a motion to that effect, to re-refer that bill to Senate on Commerce and Labor. Motion properly seconded. Do we need a recorded vote on that, or can we do it by voice vote? By voice vote, okay. Motion properly seconded to re-refer House Bill 1087 to the Committee on Commerce and Labor. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Sorry for making you wait. Okay, Delegate Orrick, what's
All right,
your
Mr.
next?
Chairman, I've made House Bill 866, and I am going to need another amendment on this one. I apologize for that, Mr. Chairman.
Look, give us time to get it in
Sure.
front of us. House Bill 866.
And, Mr. Chairman, if you want, while y'all are pulling it up, This is dealing with scenic river designation. We are adding none in this legislation, but we're trying to clean up. Because what we've been doing over the years is creating these different little bills for this designation, that designation. We haven't always gotten the language exactly the same as to what powers attach. And what this will do, the intent in working with staff, Scott Meacham, over the summer, we should eliminate about 2 pages from the code book, because we're going to say, here are the powers, you've still got all riparian rights, and here's now the list of scenic river designations. The amendment that's being proposed is what Scott did over the summer, was just pulled everything from the code books, and since we put one on the books, the name and authority over one has changed. So while we're in here, we're just going to clean it up and make it reflect the existing statute and authority over that scenic river, and that's what the amendment would do, Mr. Chairman.
Okay, you want to, can somebody report that amendment?
That would be on line 38 after body, insert or authority. On line 42 after existing, strike City of Fairfax and insert Loudoun County Sanitation Authority. The City of Fairfax no longer has authority over this designation or this scenic body, but rather the Loudoun County Sanitation Authority. So that's the reason for the changes.
All right, and those are the only two?
Yes, sir.
Is there a motion on those in a block? Motion properly seconded to amend it as reported. All in favor, please say aye. Aye. Opposed, no. The ayes have it. All right, are there any questions of Delegate Orrick on this bill?
Mr. Chairman, there's a lot of code and
Senator
text
Mason.
and change here. Are there any references to dogs or cats in
No,
these bills?
no.
I move to report.
Vote your point. And just hold that thought 1 second, Delegate Orrick. First, I'd just like to ask, is there anyone in opposition to this? And if not, then I think your motion is appropriate, Senator Mason. Is there a second to Senator Mason's motion to report the bill? Motion properly seconded to report. We're going to have to do this by voice vote because the machine is frozen.
I broke it, I'm sorry.
It breaks all the time, unfortunately. All in favor, please say aye. Aye. Opposed, no. Ayes have it.
Thank you, Mr. Chairman. members
Is
of the
there,
committee.
if there is a no, please register it so they can get that down. Okay. Delegate Hodges, you seem to be next on the sign-up sheet.
Yes, sir. Thank you, Mr.
If the
Chairman.
electronic sign-up sheet's working properly. Okay. What would you like to take,
Thank you,
Delegate
Mr. Chairman.
Hodges?
Let's go with, let's deal with stormwater first, 1308, 1307.
All right, House Bill 1308.
Topic we all love, Mr. Chairman. And stormwater, it's actually an issue we've been dealing with since my first session, and I believe we've had stormwater bills pretty much every year, and it's an issue I'm very passionate about and trying to find some solutions. And, as you know, it's very complex. Our small rural localities have a very difficult time navigating through the laws and the regulations. They don't have the expertise to deal with the stormwater. And one thing I did last year was create a work group. Senate.
The machine's frozen again. It's not giving the right number.
So,
Sorry to interrupt you. Please
You're
go
fine,
ahead.
Mr. Chairman. So how do we deal with those problems in our rural localities in the rural coastal region? I represent a district that has 1,000 miles of shoreline. You have 1,100 miles in the northern neck and over 1,000 miles on the eastern shore. It's very difficult to navigate through these laws and these regulations. So under this work group that was established under the Commonwealth Center for Flooding and Resiliency, which is a partnership with VIMS, who has the science. So we're finally really looking at and putting some science behind this. Old Dominion University, which has the engineers, and then the Coastal Policy Center at the William and Mary School of Law. We also had engineers, we had the environmental community, we had a number of localities, and the work group actually came out with these two bills as two consensus bills. Now, the first bill actually looks at the acceptance of a sign plan and review, and if you've heard of the infamous donut hole, the 2,500 square feet to an acre, this just simply allows a stamped professional engineer to stamp that plan and to move forward with the stormwater. On average, in these localities, when we survey them, only 1 or 2 of these plans actually go through these localities each year. There is no development. So this was a consensus bill that everyone approved. Very simple bill.
And just for the committee's benefit, what would they have to do otherwise?
Sir?
They've got to have a stormwater
Full
plan
stormwater. See,
otherwise, right?
yes, sir.
And I think
Actually,
that's important because everybody may not understand
right,
that.
because now, I had the opt-out provision a few years ago, so these opt-out localities that don't have the expertise, well, DEQ said, well, you still have to do it under the Chesapeake Bay Act. So it's really an unfunded mandate on these small rural localities to hire folks that have the expertise of a licensed professional engineer going to the private sector. They have the liability, they have all of the risk, and this was a consensus bill that solves a problem.
Any questions of Delegate Hodges on 1308? Is there anybody here who'd like to speak in opposition to this? Is there a motion? Motion properly seconded to report House Bill 1308. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Seems to be unanimous, Jay. Okay, 1307.
Yes,
Delegate
Mr.
Hodges?
Chairman. This also was a consensus bill from the same work group. And when the group looked at stormwater in these rural coastal regions and had VIMs looking at the science, what they found is, on average, our water is clean coming out of these rural areas. And, we kind of scratched our heads. And when they looked at this, until you hit 10% impervious cover within a certain drainage area, we're able to prove that there's no impact on the bay. So in these rural localities, you're imposing these very strict stormwater standards in these areas. And, why are you doing this to us? We can't afford it. The only type of development we actually would see would be big box development, which is not who we are in these small rural localities, the mom and pop types of businesses that we know and love. So how do we change that? And what we did is, you have that 10% impervious cover. The group looked at this, scaled it back to 7.5%, and said, all right, let's do a tiered approach going back to what they call the MS-19 standards, which is in the bill. So it's a tiered approach. So as you start out with a small amount of development, as you increase the amount of development in that drainage area, you have to step up until you hit that 7.5%, then you'll do full-blown stormwater, if that makes sense. So this really solves a problem for our rural coastal region where these laws and regulations kind of tie our hands for economic development.
All right, any questions of Delegate Hodges on 1307? Is there anybody who'd like to speak in opposition to this? DEQ need to weigh in? No? Okay. All right, is there a motion on the bill? Second. Motion properly seconded to report the bill. Just make sure I didn't miss a... No, I did not. Clerk, please open the roll.
Fourteen ayes, 0 nays.
Okay. Delegate Hodges, do you have another?
Yes, sir. I have two more. Actually, let's stay on water. We have 1035, Mr. Chairman.
1035.
Our water supply fund. All right, ready, Mr. Chairman?
I'm ready.
All right. First, I'd like to thank you for, we actually share a passion of trying to protect our Potomac aquifer. And as you know, it's been depleted at an alarming rate over the years. And with the 14 large users that have, under the new permits, drastic reductions with that, it's stabilizing the aquifer. And as we discussed just yesterday, there's no room for economic growth or in any new development. So this was one of the recommendations that came out of the Eastern Virginia Groundwater Advisory Committee that deals with the Virginia Water Supply Revolving Fund. So when allocating funds in this with the loan program, it prioritizes those projects in Eastern Virginia that create incentives as an alternative water source. So it doesn't apply, it only applies to those projects in the Eastern Virginia. So when you're comparing those projects with each other, those projects that look for an alternative use of water, it prioritizes those projects. So we're trying to incentivize those folks. Okay. That makes sense.
Any questions of Delegate Hodges on this? 1035. Is there anybody in opposition to this? Is there a motion on this? Motion properly seconded to report the bill. Please open the roll. You can report.
14 ayes, 0 nays.
Delegate Hodges, you're making this look too easy.
We've been working hard, Mr. Chairman. I think I still have maybe 4 more to come before this committee, maybe next week.
All right, which? would you
House
like
Bill
to take
1091 is the last one, Mr. Chairman.
next? All right, 1091.
This one actually deals with dredging, still on a water theme. The problem we have with our small creeks on Chesapeake Bay and the tributaries is that the funding for dredging over the years was through earmarks from Congress. Of course, you know, earmarks are no longer, they've gone away. So as these creeks have filled in, we're struggling. The Coast Guard is actually coming in and saying, we can't maintain these markers, and they're removing these markers. And when you remove those markers, guess what? Marinas suffer, no one's buying gas, bait, watermen, recreational boaters, and the creeks are no longer plotted. So folks going up and down the bay aren't coming into these creeks. We've actually shown that for every 1 foot change in depth, there's a 13% change in property value. Huge impact on these localities. So how do we provide tools to our localities to solve this problem? I actually have 5 dredging bills. One is a very easy one today, which clarifies that dredging is an eligible project so that VRA can provide financial assistance to our localities.
Okay.
It's a fairly simple bill.
Right. Any questions of Delegate Hodges on that? Anybody in opposition to this one? Is there a motion? Second. Motion properly seconded to report the bill. Please open the roll. I hope they're always that easy, Delegate Hodges.
14 ayes, 0 nays.
Thank you.
Thank you, Mr. Chairman.
Chad, when you all reset, I lost the sign-up sheet, the electronic sign-up sheet. Delegate Bloxham, step on up. I think he had a quick one anyway.
Thank you, Mr. Chairman. The first bill, I've got 2 on the docket, is House Bill 584.
584.
Now, this one, Mr. Chairman, I think I talked with you. There is some litigation in the Lynn Haven, not specific to this particular bill, but it is about transferring leases from the to the city of Virginia Beach. So I think that at this time, this bill probably needs to wait until next year to let that legal issue be resolved.
Okay. And Delegate Bloxham did speak to me about that earlier. So motion properly seconded to pass the bill by indefinitely. Please open the roll. I think he wants to PBI.
Yes. 15 ayes, 0 nays.
Okay. Thanks for making that easy. What's your next one?
House Bill 577.
All right, House Bill 577. Tell us what that does.
That bill simply allows commercial watermen who own or who have a soft crab scrape license to keep some bycatch. In Maryland,
just so the folks that may not understand what you're talking about there do understand, just explain a little bit about it.
okay, there's a soft crab fishery where you scrape behind the boat. Maryland has it, Virginia has it. Our watermen do it by hand, or they pull up the dredge by hand, and they are not allowed to keep any bycatch. In Maryland, they can actually pull it mechanically. They're allowed a bigger dredge, and they are allowed to keep bycatch. So the only thing I really want to do is allow our watermen to keep some bycatch. The bycatch will be controlled by VMRC.
Okay. All right. Any questions?
Mr. Chairman,
Senator Black.
I didn't understand a word he said. I've caught crabs, but could you just go over that?
Let me make this simple for you. It makes things less complicated for watermen. Less government overreach, more freedom, Senator Black. More freedom for watermen.
I do believe in freedom. But if you could just like in a sentence.
The soft crab fishery that we're talking about is actually, they pull a scrape behind the boat. They're about 4 feet long. They go over grass beds. And their goal is, of course, to catch soft crabs. But in the process, they also catch hard crabs. So the typical theory behind most watermen is they will throw the jimmies back, which are males, but they'll keep the sooks, which are the females, as bycatch. And the reason you throw the jimmies back is so the soft crabs go into the grass so they can catch more soft crabs. So all we're asking to do is what they do in Maryland, which is keep some hard crabs, so they help pay for their fuel, basically, is what it amounts to.
That help you? All right, any other
Yeah,
questions of
sure.
the patron?
Mr. Chair,
Senator Evans.
while I'm learning about crabs, I wanted to ask, the female crabs, you said you don't throw back?
No, the sooks.
Are they all?
The hard crabs.
Okay, so all the females are the soft crabs.
No.
So why wouldn't you throw them all back? I'm just trying to learn this.
Because they
The
typically
soft crabs in
pick
them
those
all
for crab meat.
is what you're going for. You're going after the soft crabs. But in the process, you'll catch hard crabs, which either could be sooks or jimmies, female or male. The soft crabs will be attracted by jimmies. The soft crabs are always trying to double up on jimmies. So you don't want to keep the jimmies. You want to throw them back into the grass to attract the soft crabs.
Mr. Chairman?
Senator Evans.
I don't want to prolong this too long. I'm interested in the sooks. Why don't you throw back all the sooks that aren't soft, the hard ones? That
No,
are
because
sooks?
there's a market in the picking market.
They
the-
typically.
Oh, so you
pick-
can
for
use
crab
them.
meat. Oh, yeah,
So
oh,
the,
yes.
the
yes.
crab meat,
Crab meat.
the crab cake you eat in a restaurant typically is the female crab that's been picked out.
Okay, thank you.
Senator Marsden.
Thank you, Mr.
I'm
Chairman.
blushing here. I don't know about you guys, but I'm getting a little embarrassed.
Mr. Chairman, can you,
Senator Marsden.
thank you, Mr. Chairman, can you assure me that there's no Title IX violation here?
If there are no serious questions of the patron, is there anybody opposed to this? Seeing none, is there a motion? Motion properly seconded to report the bill. Please open the roll. Please say aye. Aye. Opposed, no. The ayes have it.
Thank you, Mr.
Note your
Chairman.
nose. Thank you, Delegate Bloxham. Delegate Wright, you just have to note your nose if you didn't like that bill. Delegate Wright, what do you have?
Mr. Chairman, I have House Bill 211.
House
This
Bill
comes out of the
211.
Eastern Virginia Groundwater Management Study, and it simply lengthens the term from 10 to 15 years, the maximum term of a groundwater withdrawal permit, and the cost goes from $6,000 to $9,000, which would take care of the extra years. This was worked out as part of the study by the Eastern Virginia Groundwater Management Study, and it was brought before the State Water Commission, and I'm bringing it on that behalf.
Okay. Any questions of Delegate Wright on this? And I think this is supported by DEQ as part of a stakeholder workout. Anybody opposed to this besides me? I'm kidding, Delegate Wright. That's another story. There's a motion properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Is that all you have?
Yes, sir.
Thank you.
Thank you.
Delegate O'Quinn. He's not here. Oh, yes, he is. Sorry. I thought some of y'all had to leave. They all have to leave. It's 3:15.
I have two bills, Mr. Chairman. You can take whichever one you like.
Delegate O'Quinn. No, what would you like to take?
6, whatever it is, 32, I think.
You don't even know?
I don't know if you don't.
It's an easy bill.
635.
635. Yeah, Mr. Chairman. House Bill 635 allows the Department of Game and Inland Fisheries to set up an alternative free fishing day. We've had, it takes board approval to set the first one up. If that event is rained out, which we've had a few years, then there's no mechanism for setting up an alternative date, and this provides for that.
Okay. Any questions, the delegate? Anybody who's opposed to this?
Only
Seeing
people who don't
none,
like kids.
is there a motion? Motion properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Is that all you have?
I have House Bill 812.
House Bill 812.
Mr. Chairman, House Bill 812 codifies the Commonwealth's participation in the Interstate Mining Compact Commission, which requires the governor to have an advisory body to assist with those issues. What it essentially does is takes two existing bodies and moves them into one to handle the functions that two are currently handling. There's a lot of overlap, and the Department of Mines, Minerals, and Energy, as well as all the stakeholders, have agreed that one board can do the work of two. So this is what that bill does.
Okay. Any questions of the delegate? Less government.
Less government.
Anybody
definitely.
opposed to this?
Streamlining.
Anybody like to speak in opposition to it? Is there a second? Motion properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no. That all you have?
That's all. Thank you,
Thanks,
Mr. Chairman.
Delegate Quinn. I need to step back on House Bill 211 that Delegate Wright had, and if we can get a motion to reconsider that. All in favor of that motion, please say aye. Aye. Opposed, no. And if we could get a reformed motion to report that bill and re-refer to Senate Finance, I missed that. Motion properly seconded to report the bill and re-refer to Senate Finance. That's House Bill 211. It was Delegate Wright's bill, withdrawal permit bill. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Delegate Freitas.
Thank you, Mr. Chairman. House Bill 1479.
1479.
Yes, sir.
Okay, tell us about that.
Okay, so here's essentially what is happening. Right now, a parent will sign a waiver for a child to go to a horse show. Once they show up, the horse show requires that they actually see someone sign the waiver. So what this bill would essentially do is that when there is a duly assigned representative of the parent, they could then sign the waiver at the horse show itself, provided that they've already got the waiver from the parent and whatnot, and children can participate in equine activities.
Okay. Don't explain that in too much detail, or Senator Peterson will start, he'll start he's one of those trial lawyers.
Yeah.
Are there any questions of Delegate Freitas about this? This just allows a representative of the parent to actually sign a waiver form. And I know a little bit about this because I've got a child who did it who's now over 18. But most of the folks are not going to let you use their property for these activities unless you have a waiver. So you would be taking away property from little children to ride their horses if you vote against this bill, Senator Peterson. Any questions? If not, is there anyone who'd like to speak in opposition?
Well, Mr. Chairman.
I know we're not supposed to ask questions.
Senator Evan.
So if, Delegate, if the other person signs the waiver, are they liable then if they're misrepresenting the parent?
I mean, again, my assumption that is yes. What we're trying to do is provide for the liability of the facility so that they can actually participate in the equine activity. But yeah, if someone engaged in a fraudulent, signing that waiver, they would not get liability from this.
Thank you.
No problem with that.
Any other questions? Oh, Lord, Obenshane's looking at it cross-eyed now. There's a motion. Is there a second?
Well, wait.
Motion properly seconded.
Wait a second. Slow down this train. I
tried to help
since
you.
Senator Peterson is apparently too shy to ask these questions, so if you send your child on a field trip, what is a duly authorized representative of a parent? Is that the teacher?
Well, again, the way I understand it is that the parent has signed the waiver, understanding that they're going to a horse show. And then we have some people right here the lambs that regularly participate.
Well, in this context, it would be the child's trainer. So it would be
Correct.
the person who looks after the child, that teaches them how to ride, that helps them ride, that supervises them while they're there, and that has the authority of the parents to take that child to the horse show and participate in the activity.
Correct.
That's their duly authorized representative.
Well, Mr. Chairman, thank you for answering that question. Where does it say this is limited to horse shows?
Well, I believe it's limited to equine activity.
Exactly.
Unless I'm misreading it.
An equine activity.
Sponsor.
What is an equine activity? I mean, is that horse riding on a farm? Does it have to be somebody skilled in hosting children. Look, I completely understand what the patron's trying to get at, and if this was limited to horse shows and the trainer who had permission from a parent and a parent understood what they were giving this person permission to do, I'd be fine with this. But if my child goes on a field trip with the school and I don't even know that they're going to be given an opportunity to ride horses, and the teacher signs on behalf of all the students and my child falls off, I mean, I can imagine a parent being kind of upset.
Senator Stanley.
Mr. Chairman, equine activity has been defined in the code. It is a pretty big definition. Goes to equine shows, fairs, competitions, performances, parades, involve any or all breeds of equines and any of the equine disciplines, including dressage, hunter and jumper, horse shows, Grand Prix, 3-day events, combined training, rodeos, driving, pulling, cutting, polo, steeplechasing, endurance. It goes on and on. It talks about riding, inspecting, that's a part of the equine activity, evaluating an equine, rides, trips, hunts, or other equine activities, and goes on and is defined. Conduct regarding general hoof care, replacing hooves, horseshoes, breeding, therapeutic veterinary treatment. So, I mean, it's well defined. So, I mean, it's pretty widely defined it's a pretty broad interpretation of what equine activity is. So I think it encompasses everything.
That's what I was afraid of.
We're going to let Mr. Lamb speak. He stepped up. Would you like to speak to this?
I'm David Lamb from Gordonsville, Virginia. Many of y'all know me. I've been in business for a long time. What the representative would be a person like me that I have a signed waiver for my farm, that the child will come to my farm. This is all about minors and will ride. But where the things have changed over the years from the time the equine liability law was created, the family unit was different a few years ago. You had mother, fathers, and children in one home. We get a lot of children brought to us nowadays from a single mother that has 2 kids. One kid may be going to soccer, one may be going to the horse show. So in order for us to legally take them to the show, we have a signed waiver at my farm. So if I load them up to take them anywhere for equine activity, as he just described there, then I need to get a signed waiver per the other farm that we take them to. And this would be, I would be a representative delegated by the parent to take the child to the function. So it's nothing haphazard about it. It's cut and dried. It wouldn't be going to a school bus trip or whatever. In that case, then they would have to be signed by the parent.
Senator Obenchain, does that help you?
It does not with respect to the breadth of the bill. I mean, I understand the situation that's being described, and I would be happy to accommodate that, but especially given what Senator Stanley read, I mean, this basically applies to anything where a horse is in the vicinity. And I mean, we've made a policy decision previously that, you know, while releases are void is against public policy in Virginia for most things, they're not for equine activities, but only to the extent that a parent signs it. So this is a big change in policy in Virginia. And I mean, I'm just, you know, I probably would have been okay with the change to make sure that, you know, a parent, well, to provide a parent with the ability to waive liability, although that's a stretch. I think we can waive liability for ourselves in limited circumstances, but, you know, this is a big change. We're delegating the authority to a third party, or fourth party, to waive liability on behalf of a child. I mean, this is not waiving liability on behalf of an adult, but on behalf of a child.
But it's done with the parent's knowledge. It's done with, they are acting as an extension of the parent.
A duly authorized representative, where does it provide that, I mean, it may be a duly authorized representative of the parent to take my child on the field trip, But are they duly authorized to sign a release?
Inherent in the statement duly authorized is the permission to sign that release. Otherwise, they wouldn't be duly authorized.
But where does it say that?
Mr.
Well, it says it right here.
Duly authorized
Senator
representative of a parent.
Just to help Senator Obenshain, and I'm not a lawyer, so maybe this isn't any help, but maybe counsel can clarify. If it was necessary, and I don't know if it would make him more comfortable, what if we added a sentence saying something to the effect of a duly authorized representative of a parent who the parent has authorized in writing, may for the specific circumstances. So in other words, they get a real permission slip from the parent to bring them onto the farm or for the activity in general.
Well, why can't?
Let me ask Scott, is there any confusion in the current language, Scott, as far as you can see it?
Mr. Chairman, I can't speak for everyone, but I would interpret duly authorized representative to mean a representative who is duly authorized to execute the waiver that is addressed in the bill. Yes, sir.
I would feel more comfortable if it said duly authorized in writing, but in that event, why wouldn't the parent just sign the waiver?
Mr. Chairman?
Because, I'm sorry, Delegate Freitas.
Mr. Chairman, I know in some cases, and I know Mr. Lamb can also testify to this, in some cases, they require at the horse show to see in person when you sign the waiver. I'll just put in a real quick thing. The issue that we have right now is that if we can't get some sort of resolution in how this is possible, there's going to be a significant number of activities that are not going to be permissible anymore. So I guess my question would be, would it be possible for this to go by and perhaps do some?
Well, hold on just a second. Senator McClellan.
Don't be afraid of the open chain. Don't be afraid of the open chain.
He just wants to make me explain this on the floor, that's all.
Right. Mr. Chair.
Senator McClellan.
Before it goes by for the day, because I want to make sure there might not be another issue, what is the legal effect of the change on line 20 to 21? We've replaced specifically enumerated under this subsection with or intrinsic dangers of equine activities. And this might be more for counsel, but
Can you address that?
what does that mean?
Mr. Chairman, that's actually a technical change. That section used to enumerate all of the risks, and when those were taken out, we just didn't change that language. So that's should be purely technical.
Well, Mr. Chairman,
Senator Odenshine.
And I'm hesitant to disagree with counsel, but it's not the case, I don't think. I mean, I think that what this required was, for a waiver to be valid and binding, the risks you were waiving had to be set forth in there. And this said that the waiver only covered the risks that were set forth in writing, which informed the parent or the duly authorized representative of the parent what those risks were. What this says is you don't have to inform them in writing what the specific risks are, but if it's just something inherent in the activity, you don't have to specifically identify them. Just say you're waiving all risks inherent in this equine activity.
Maybe we ought to give you a week to work with Senator Odenshine on this. I don't think he is opposed to the concept of doing this. He's just concerned about the language, and perhaps you all can work on some language.
I would certainly appreciate the time, Mr. Chairman, to tighten it up.
Without objection.
Can I just offer one suggestion?
Sure,
Is
Senator
that
Marshall.
it seems to me that if this is one of these things where there's going to be a consistent activity that a coach is going to be taking this kid around, just exercising some kind of a power of attorney that spells out what the equine activity is and that this person is authorized to sign. You do that once, and then you're good for all those events. That person is eligible. So maybe look at that as one of the possible solutions to the problem, because I'd like to see you solve it.
So let me just, if what you're trying to do is if a parent was taking the child and they would sign a waiver on site, and the waiver would spell out what all the dangers are that child could face on their visit that day. If all you're trying to do is get the parent the ability to sign the waiver off-site because they can't physically be there, that's one thing. So long as the parent has in front of them something showing all of the inherent dangers, they sign the waiver, but the babysitter can deliver the waiver. That's one thing, and I'm fine with that. But the way that's written right now is parent designates babysitter, take my child, and then the babysitter signs the waiver, and the babysitter might not know the inherent dangers of what that activity that child is going to be. So I kind of agree with Senator Obensch. You got to make sure that the parent is fully informed of what's being signed, and it's the parent that signs it, I don't care where, and not the babysitter.
And just to that point, we're not talking about episodic events. This isn't where somebody just happens along one day and says, "Oh, can I take your kid to a horse show?" These are children that are committed, and they have a great deal of investment in this with the potential gear. They spend a lot of time being taught how to ride and participate in these things. The thing is, they go from place to place participating in these shows, and each one of these facilities requires a waiver because riding a horse is dangerous, and the parents understand that.
And I understand that. What I'm trying to make sure, the example that was given is the mom can't drive the kid to the show. So the babysitter doesn't understand, may not understand all of the inherent dangers, but the way I see that they could be, but they could not be. I mean, I all the time would, so my point is, I want to make sure it's the parent that is signing the waiver. And if the issue is the parent can't physically show up to the place and sign the waiver in person, I'm okay with fixing that. I'm not okay with giving someone other than the parent who may be a babysitter, like I call my sister and say, take my child, but my sister doesn't know anything about horse shows or horses. She's just a ride. I don't want my sister signing that waiver. I want to be the one to sign it. That's my point.
Practically speaking, I'm not sure it applies in these situations, but I understand your point. Senator Dance.
Thank you, Mr. Chair. I'm listening to everything, but my concern is this, that I know that I'm one of those Grammys that have kids from out of state, and I get permission, but most forms, things I'm taking them on, and zip lining and all that stuff, there is an electronic form that I can either give her the link to fill it out, and then I can use that, where she's seen all of the requirements, and then she says, this is, and she signs electronic sign or give me permission. But I get to see this. If these are sophisticated events that occur over a period of time, isn't there some way that they could get the written document or whatever it is that parents need to see and still authorize that person once the parent has signed the document and is then authorized that person? Yes, I'm agreeing for you to do X, Y, Z, then you can go forward with that.
Mr. Chairman, I would say that in some cases there are, in some cases that there aren't, or they don't do that, or the specific horse show requires, presence of somebody authorized to be able to sign in person that they want to see. But again, I'm very happy to, again, go by and work and to address these concerns, because again, what we don't want to happen is a situation now where unless you have a parent present, because if that is the case, there are going to be a lot of students right now that are no longer able to participate in shows that they have for years. But again, I'm very happy to work with all the stakeholders to address those concerns.
All right, thank you. Without objection, this will go by for the week.
Thank you, Mr. Chairman.
Thank you. Let's see. Delegate Bulova, I think you're next.
Right,
what do you have, Delegate Bulova?
All right, I got three bills. We could start off with House Bill 358.
Okay, House Bill 358.
All right, and House Bill 358, this is a collaborative effort between the Department of Environmental Quality as well as the Home Builders Association.
I've got Dave Paler, who's happy to go ahead and provide any testimony, and Andrew Clark is also here. The primary purpose of the bill is to ensure that when you have new development that is occurring in one of our groundwater management areas, that number one, those new residents of the subdivision, that they are protected for the long term, that they're going to have a long-term water supply. And then number two, making sure that when you have this new development that goes in these sensitive areas, that you're not negatively impacting the people who are already living around them. And so what the bill does is addresses the following problem. And so under current law, as I think y'all are aware, any entity within one of our groundwater management areas that withdraws more than 300,000 gallons of groundwater per month has to apply for and receive a permit. But at the same time, if you have a development, a subdivision that's going in, and each of those individual lots goes ahead and has an individual well, you can actually withdraw a heck of a lot more than 300,000 gallons per month, and you aren't required to have any kind of permit as a result of that development. And so in working with DEQ, my time up?
I don't know what that was.
Or maybe I hit the jackpot.
Tell him what he's won. A new car.
Yay.
Just sort of a...
Anyways, the home builders understood why this was important. They agreed that it was an issue that needed to be addressed. What they didn't want was a new permit requirement. And so what they did, they worked very closely together to come up with this particular bill. And so what it does is really kind of 3 steps. And so if you have a subdivision that's 30 or more individual lots, and each of those lots is going to have its own water well, you have to apply for a non-binding technical evaluation from DEQ. And so what DEQ then has is 60 days to provide this technical evaluation. And it's really just looking at making sure that the water supply that the developer is proposing is going to protect the neighboring properties. It's going to be beneficial and adequate for the subdivision that's being proposed. It's non-binding, and so when the developer gets that, the developer certainly has the option of saying, nope, sorry, we think our plan is better, but they do have to submit a mitigation plan to DEQ. And again, once the developer leaves, you're leaving some property owners there, and you need to make sure that there's some kind of mitigation plan out there just in case you do wind up with water supply issues. I'd note that the requirement only applies to your deeper aquifers, the ones that are vulnerable, so not the superficial aquifer. So if you stick with the superficial aquifer, you don't need to go through any of this process. Anyways, that's the nature of the bill, Mr. Chairman. And again, we got DEQ and the home builders who've been working on this, and happy to speak to it.
Delegate Bulova, is this a recommendation from that work group as a result of the depletion of the aquifer? Or did you come up with this on your own?
No, this was actually an issue that DEQ raised about 3 years ago. And they had actually asked to put in some permitting requirements. That did not go through, generated some really good conversation. But it also raised an acknowledgement from the home builder separate from all that whole process, saying, yeah, we understand that this is an issue. Let's sit down and work through how we're going to go ahead and protect the subdivisions and the groundwater aquifers. So this is a whole separate process, but it was brought to me by the administration.
And typically, if a developer is going to develop 30 lots or more, don't they generally have an engineer that's working on that and would already do this sort of analysis to ensure that they did have water for those homes?
A good developer would likely go ahead and do that, but again, there's no permit required for that, and so that's not part of any of the review process.
But practically speaking, what developer is going to try to get a plat approved for 30 or more lots without having an engineer on staff to do that? They got to draw all the drawings. They've got a bunch of other investigations to do, and typically, wouldn't they also do some sort of investigation on the water?
Yeah, and maybe if Andrew might be able to speak to the process.
But before them, I want to ask you these questions.
Sure.
And if I understand this bill correctly, you're going to charge them a $5,000 fee to perform an evaluation that they then don't have to follow.
Well, and again, Mr. Chairman, $5,000 for the entire project, and so when you split that cost out over a minimum of 30 lots, that's actually a relatively minor cost in order to go ahead and do that technical evaluation. And again,
You don't get to pay that over 30 building permits. You've got to pay them when you initially are required to get this technical evaluation. You've got to pay them $5,000 for that evaluation, and then you don't even have to read it or pay attention to it.
Well, Mr. Chairman, you do have to read it and pay attention to it, because if you disagree with the evaluation and still want to move forward, you also have to supply a mitigation plan to DEQ, to ensure that, again, if DEQ is coming in and saying, hey, look, you potentially have a problem here, this is how you need to deal with your water supply, that again, what you're looking at is protecting the future residents, who are going to move in long after the development has been settled and the developer is gone.
And Delegate Bulova, I'll apologize to you in advance. This whole issue just frustrates me tremendously, because we continue to look at restrictions on homeowners who have to pay for that when we have a much larger issue of industrial withdrawals, which, and I've talked with folks about that, we're draining our aquifer to bleach paper with it. And to me, that just makes no sense. And instead of addressing the issue at hand, we're coming around and putting all these little restrictions on homeowners. And then we talk about affordable housing. Well, every time you add these fees onto it and these difficulties, and that much longer to get an approval for a site plan increases the cost, not to mention the fee, it just continues to drive the cost of housing up.
Right.
And
Mr. Chairman?
Senator Evan.
Yeah, I had a question actually for Mr. Clark. Does this make it easier for home builders who want to make sure that the water is not draining wells up front and avoid a lawsuit later?
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia. I will admit a lot of the work on this bill was done under my predecessor that you may know, who recently retired. We do support the bill, but going back, I think it came up 3 years ago. Patron was very gracious in working with us and DEQ and a lot of other stakeholders. So I'll admit there's probably more technical experts from DEQ, but we do support the bill and see it as a good way to protect some of our water resources.
Mr. Chairman?
I'm Senator Evan.
Just ask DEQ.
Senator Evan.
I'm reading this, and I don't know if I'm reading it wrong, but does this help developers protect make sure there's not water problems with the rest of the development and protect them up front so there's not a problem later?
Mr. Chairman, Senator Eben, I would say that it does protect not only, it is aimed at protecting, assuring that the water is available for that facility, but it's also aimed at minimizing impact on either side. I would characterize, I would say that that I would take issue with the chairman's characterization that the developers would be able to do this kind of evaluation, because this is some modeling and things that aren't generally available to the contractors. Part of the idea here is there are actually as many as 5 different aquifers that you can pull from. And the idea behind this is that we would give advice to the developer as to which of those 5 aquifers is most sustainable and provides the quality and has the least impact on the rest of the aquifer.
Any other questions? Yeah. Sorry, Senator Mars.
Thank you, Mr. Chairman. Just a comment. It's an old saying, you start where you are, you use what you got, and you do what you can. And I share your frustration in terms of these big users and whatever, but I think that's a different bill. In the meantime, nobody has been more cognizant of the problems with the aquifers than you have. But this may seem like a small thing and you're inconveniencing folks, but this is something that I wish we could get to the big guys first and then work our way down. But this is what we can do at the present time, and I think we need to move forward with this bill.
Any other questions to the patron? Is there anybody who'd like to speak for or against this? I guess y'all already did. Is there a motion? Motion properly seconded to report the bill. All in favor, please say aye.
Aye.
Opposed, no. No. And accept my apologies. I'm very frustrated over this whole situation, and you're just kind of caught in the middle of it. But
Also make mine a no.
we need to take bigger steps in this, Delegate Boulevard. Your bill passes.
Thank you. And
Is
I
that
got,
all you
got
had?
two more that I'm
Two
hoping
more,
are easier
okay.
than that one.
Which
yeah.
which other one would you like to take?
We can do 377 because that's a
House Bill 377.
Yeah, and let me just say, Mr. Chairman, before we go on, I completely get where you're coming from. And the last bill, I just kind of concur with Senator Mars, and it's a way to go ahead and make sure that we're managing for those who are moving into those areas so they don't run out of water. All right, but moving on to House Bill 377. What this bill does is that it clarifies that a Virginia water protection permit isn't required when you modify or replace a stormwater management facility that was created on dry land for the purpose of conveying, treating, or storing stormwater. And so all this does is really recognizes the fact that when you're talking about a stormwater pond or a stormwater management facility, that it's a piece of infrastructure. It's not like an open natural channel or a stream or a wetland that you need a permit for. And so we have an interesting quirk where at the federal level, they've already acknowledged this fact and you don't need a permit. But in Virginia, you do need to have a permit. And so I'll give you a quick example. So if you are redeveloping a project and you want to take an old facility that doesn't perform very well, rip it out, and put in a brand new facility that gets a lot more efficiency to it, removing pollutant, you actually have to get a permit for that, even though you're actually improving the environment as a result. And so that's all this does, is it really kind of matches up at the federal level. It is supported by the home builders, manufacturers, the Chesapeake Bay Foundation, so they're all on board with moving in this direction.
Okay. Any questions of Delegate Bullitt on this? Is there anybody in opposition to this? If not, is there a motion? Motion properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Okay, what's your next one?
All right, so the next one, I believe, is 925. And so if you thought that was interesting, you'll love this one. This deals with the relationship between a municipal separate storm sewer system permit, and I know you all know what MS4 permits are, and industrial stormwater permits. And so the easiest way to describe what this bill does is it says that if you have permit A, your MS4 permit, and you have permit B, which is your industrial stormwater permit, is that you can't use permit A to help DEQ enforce against permit B. And so it's essentially kind of stay in your lane kind of thing, which is they're both DEQ permits. DEQ should be responsible for enforcing those. You shouldn't be using one permittee to go ahead and enforce permits for another permittee. In this case, this deals with industrial and high-risk runoff programs. And so the last time there was a permit put together in one of these, localities are required to have these programs, but I think because of some push from EPA, DEQ put language in there that made it so these localities are partially responsible for enforcing these industrial stormwater permits, which again are separate permits for DEQ. And so this just right sizes that ship, makes it really clear that, yeah, locality should have an industrial and high-risk program, but you shouldn't use that to help DEQ enforce their permittees. DEQ is fine with this. Bay Foundation, Virginia Manufacturing Association, everybody else has bought off on this.
The Association of Counties okay with this?
Yes.
Okay.
Yeah.
Any questions of Delegate Bullitt? Is there anybody in opposition to this? Not, is there a motion? Motion properly seconded to report this. All in favor, please say aye. Aye. Opposed, no. Delegate Bullitt, before you use, just believe, we need to have a motion to reconsider House Bill 358, not because I'm going to try to kill it or anything, but it does have to go to finance, and we missed that.
By which 358 passed the amendment that we reconsider that vote.
Is there a second? All in favor, please say aye. Aye. Opposed, no. The ayes have it. Is Senator Stanley moves that the bill be reported and re-referred to Senate Finance. Senator Mason seconds that. All in favor, please say aye. Aye. Opposed, no. I'm a no. I guess they're the same no's that were before. Register your no's. Thank you, Delegate.
Very good.
Bowles.
Thank you very much for your time.
Let's see. My machine is not functioning right. Who was next between the two of you all? And I apologize for that. We had an electronic sign up and it just went kaflooey in the middle somewhere, so.
Mr.
Yes,
Chairman, here for House Bill 286.
House Bill 286.
And I don't know if Senator Black approached me and said he had an amendment for this.
Let's hear your bill first.
All right. Mr. Chairman, what this does is allows wineries to, if they so choose, to allow dogs on the premises as long as they're not in the area where food is manufactured. We have a rapidly growing wine industry. We had a very packed wine caucus last night. In my district, we have quite a few wineries. And previously, they were at their own choosing, allowing people to bring dogs on the premises, often in a nice summer day, enjoy a glass of wine, and have their dog run around in the countryside. The Department of Agricultural Consumer Services started enforcing the food laws on this, which are mainly related to food manufacturer, and no longer would allow them to do this. Okay. So I was approached by several of these wineries, and I actually have one owner of a winery here today to speak to this. Okay. That's why I did the bill, so they would be allowed to do it. We went into great detail on which the owner of the winery can do, not my area of expertise, but the way my wine is made, basically, it's not the alcohol is produced. It does kill germs, and this is not going to be, the dogs won't be in the area where the wine is produced. So it doesn't have a sanitary issue. And again, it's at the discretion of the winery.
Okay. Delegate Bell, first, any questions of Delegate Bell on this? If not, would you like to have your witness testify, or you want to talk about this substitute first?
Your pleasure, Mr. Chairman.
Well, I want to ask Delegate Bell first.
Yep.
There is a substitute, and Senator Black has discussed this with you, and you're not concerned that it
Mr. Chairman,
injures...
actually, I will tell you, I think it's a friendly substitute, and I concur with it. After my bill passed the House, I can tell you I was approached by several distilleries and farm breweries asking if they could have this too, saying that they were having the same problem. And since the sanitary issues are the same, I think it's a good way to help growing businesses. And for the Freedom Caucus, I'll say this is a way to prevent government overreach.
Okay, is there a motion on substitute? Motion properly seconded to adopt substitute. All in favor, please say aye. Aye. Opposed, no. The ayes have it. And just for purposes of the audience, Delegate Bell, this just brings in a farm brewery, and that's it, correct?
Distillery as well, Mr. Chairman.
And a distillery, you're correct. Okay. All right, would you like to have your witness come up?
Mr. Chairman, if that's all right, yeah, I will. He
yes, please do.
Mr. Chairman, committee members, thanks for letting me speak today. My name is Brian Roeder. I'm the founder and owner of Bear Oak Winery in Delaware Plain, Virginia. We've been in our business for about 10 years, and we're located in Fauquier County. I'll keep my comments very short. I'm the past vice president of the Virginia Wineries Association, the founding treasurer of the Virginia Wine Council, past president of both the Fauquier Wine Council and Warrenton Regional Chamber of Commerce. I'm also a former board member of the Virginia Tourism Corporation. I'm here today to support HB 286. I believe that our extensive experience with dogs at wineries can provide important factual evidence which supports this bill's passage. We are one of Virginia's busiest wineries, each year serving 50,000 customers and about 4,000 companion dogs. On a busy day, we'll have as many as 150 dogs on our site. In 10 years, there has been not one hospital visit, not one insurance claim, and not one lawsuit for our organization due to dogs. While we do not advocate allowing dogs into restaurants or food preparation areas, there are no discernible health impacts to having dogs in wineries. Food can be infected by bacteria that is harmful to humans, but wine is alcohol, which is used to kill bacteria. Because people are drinking at wineries, many of us offer the food options, various types. Winery food services are stringently regulated by VDACs. Winery food is not cooked.
Just so you know, I think we all like your bill.
Yeah, it's a good bill.
I think we all like your bill.
I'm almost done. I think it's a good bill too. And it's not mine. The smarter people than me came up with it, sir.
I think we all like the bill.
Winery food is not cooked to serve. It is prepackaged and regulated by UDAX. That's the key thing. I hope you'll support the bill. Thanks for your time. Appreciate
Thank you.
Yeah, absolutely.
Anyone else who'd like to speak in favor? Any opposition? Let me call for opposition.
I can do it in the 15 seconds. Jim Turpin, Virginia Wine Council. We support the bill because it provides flexibility for wineries that want to have dogs, but it doesn't say the ones that don't have to. Thank you.
Thank you. And just to be clear, is there any opposition on this? There's no
Not that I know of,
opposition
Mr.
on this.
Chairman.
Is there a motion?
Move to
Motion properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no. Ayes have it. I'm sorry? Let's not complicate things, Senator McClellan. Okay, thank you, Delegate Bell. Yes, sir. No. No cats. Come on up.
Morning. Thank you, Mr. Chairman, members of the committee. HB 424.
424
is hopefully a very simple bill to end your day. It passed uncontested in the House. It allows animal shelters to vaccinate the animals in their care to prevent communicable diseases.
Senator Stanley said he's killing all the dog bills that come through from now on.
I did not.
I do have people here in support if you want to hear from them.
Any questions of Delegate Levine on this? Is there any, Senator Obenchain has questions.
Just
Senator
question.
Obenchain.
Just as a practical matter, if one of these dogs is claimed from the shelter, are the owners charged for the vaccinations?
I don't know the answer to that, but maybe, Heidi, do you know the answer to that?
I think as a general practice, they probably do not pass that cost on, but they can pass on the cost of impoundment, which may in some way include those costs.
All right. I mean, and I have no idea the answer to this, but I take it there's no harm in double vaccinating a dog. I mean, how do you know whether it's been vaccinated before?
You may or may not know it's primarily due to strays being in your custody where the shelter doesn't necessarily have ownership at that moment, but it is required to work with a veterinarian for a protocol so that if there is any issue of over-vaccination, the protocol could address that.
Okay.
Okay. Any other questions? Is there anyone who'd like to speak in opposition to this? To vaccinations? Okay, is there a motion? Motion properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no. Thank you for waiting. Register your no.
You know like this.
Register your no.
Thank you, Mr. Chairman, members of the committee.
Yes. Martha, come on up. I know you're trying to help out a sick delegate. We appreciate that.
Thank you, Mr. Chairman.
You've got House Bill 844, Delegate Ferris, is that correct?
Yes.
Okay. Excuse me? The boy is sick. Yes, he is. I've confirmed that.
Martha Moore, Virginia Farm Bureau. Yes, Delegate Ferris, we support this bill. It defines the terms orchard and vineyard for the purposes of the exception to the ban on burning brush where such burning is done to prevent frost damage to orchards or vineyards. Last year you expanded this. We did not realize there was not a definition. Someone's here from the Department of Forestry if you have any specific questions, but we hope that you will support just this clarification.
Okay. Any questions, Martha? Anybody opposed to this? Is there a motion?
Move to report.
Motion
Second.
properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no.
Don't go
The
anywhere,
ayes have it.
Martha.
Martha, they may need you on something else. Not on this bill, but, or on this bill?
Can we do Delegate Wiltz while
Sure.
she's up?
Sure. What number is Delegate Wilt's bill?
House Bill 1152, the Beehive grants.
House Bill
I'm sorry.
1152.
We'll let Katie do that.
We'll let Katie do it.
Okay.
I don't even
Mr.
have the bill in front of me.
Mr.
Mr. Chair.
Please tell us who you are,
I'm
what bill
Katie
you're
Frazier
presenting.
with the Virginia Agribusiness Council. We worked with
Delegate Will, this is an update to the Beehive Incentive Grant Program, which the legislature passed several years ago. Last year in the budget, there was language to ask the Department of Agriculture to study this program to ensure that it achieved maximum efficiency of the funds that are used. What this bill would do would be to create a mechanism where the department could actually purchase beehive kits. They can do that more efficiently and at a more cost-effective manner, and that way they can actually distribute more beehive supplies to potential beekeepers around the state. So this, I believe, is supported by the beekeepers generally across the Commonwealth, and we do support the legislation as well. And I believe there have been budget amendments that have been filed on this on the Senate side.
But I'm not aware that this has to go to finance, so. I don't
Have
know
a
if there
fiscal
has
impact.
Well, then we're good.
Are there questions of,
Yeah. Is it
the
really
surrogate
limited?
patrons?
Yeah, I'd ask the surrogate patron. If, it says here may apply in the summer at least for no more than 3 basic beehive units per year. With all the bees dying, why is it limited?
That's to ensure that the amount of kits can be distributed across the state to the maximum amount of beekeepers, so that one beekeeper doesn't come in and request all of the kits that might be available with the available funding.
Thank you.
Senator Dance? No question? Okay.
Mr. Chairman,
Senator Sudeline.
I've got a question on this.
Okay, I don't
You
have
had
the
to
bill in front of me.
anticipate
Everybody
that.
has it.
Well, it's more about the larger program. Do we believe that if we didn't have this grant program, these beekeepers wouldn't be doing this?
I'm going to perhaps call on resources from the Department of Agriculture. I believe someone is here who worked on the study for this summer.
Well-
They did, I think, some surveys with beekeepers about this, so they can report on how many beekeepers have actually taken advantage of this program.
Mr. Chairman, before the Department of Agriculture comes up, Katie, my understanding is that this bill really doesn't go to the efficacy of the program. The money is already there. It simply cuts off the grants and says, instead of grants, we're going to give out bee kits. The money is there, and if this bill doesn't pass, then we're still giving out grants, but a more limited amount. And this bill simply is intended to get more bees out there. So, if we don't pass this, it doesn't solve of any philosophical concern with whether General Assembly ought to be putting money in this. It just means we're going to be giving money away rather than giving bees away.
The other provision
you,
in this
Senator Richard.
this legislation is that it does allow for the department to not collect applications for these kits should there not be any funding. Right now, present law requires that the department continue to accept applications even if there's no funding. So what you have is really a backlog of folks who think that there's actually funding for this program and submit applications, and then it's not there. So that's the other cleanup measure with this.
Okay. Is there anybody in opposition to this? If not, is there a motion?
Move to report.
Motion properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no. Register your noes if you have one. Okay. Senator Obenchain, you have another?
I've got Delegate Knight's bill, House Bill 821.
821.
My understanding is it's simply a conveyance bill. It conveys, it allows the state to trade 4.7 acres of land in Little Island Park at Sandbridge in Virginia Beach to the city of Virginia Beach in exchange for 70 acres of city land with boat access to Back Bay. Apparently, both parties are in agreement, and I think this has been checked out by the AG's office.
And just so you know, this does have to be re-referred to finance. And
Is anyone here from Virginia Beach?
if you have any questions, I see the
This-
director there.
I have a question.
No, Clyde is here.
Angie. Yes, sir. Where the land that I know exactly where Little Island Park is. Where exactly is the land we're obtaining for the Back Bay access?
I do not know exactly.
Let's let the Director of Conservation and talk,
Thank you,
answer
Mr.
that
Chairman,
question.
members of the committee. Clyde Crispin, the Director of the Department of Conservation and Recreation. I have a handout that I could show you, Senator Peterson, but in effect, we acquired this land in the late 1800s from the former Coast Guard station that is right there where the fishing pier, if you're familiar with the little
Sure.
island, we actually own the 4.7 acres where the fishing pier is. The city would like to acquire that from us to be able to do some improvements on that property. Actually, what they want to do is tear out a paved parking lot.
Right.
And then exchange, they're going to give us all of this in yellow. That's approximately 70.94 acres. I think it's a pretty good deal for the Commonwealth as well as the city. And I do have a letter in my file from the city of Virginia Beach in support.
One follow-up question, Mr. Chair. Are you going to put in a boat ramp back there, or what are you going to put in facilities?
Thank you, Senator Peterson. There is currently a canoe and kayak launch there that we will then be able to charge parking, and we will be able to allow people to put canoe and kayaks in on this particular area that will allow them access to the state park.
Public access. Any other questions? If not, is there anybody in opposition to this? Is there a motion?
Move to report.
And re-refer to Senate Finance. Motion properly seconded to report and re-refer the bill to Senate Finance. All in favor, please say aye. Aye. Opposed, no, or register your noes. Thank you.
Thank you, Mr. Chairman.
One last bill.
Senator Obenshain.
House Bill 359 from Delegate Rush. Right now, we've got apparently essentially a 10-day quarantine period for dogs who've bitten somebody. And what this does is it directs, I guess this directs that in determining whether to impose that 10-day quarantine, that the health director take into consideration whether the dog in question is a police dog or a working military dog. Presumably, the notion is if it's a police dog, it doesn't need to be quarantined.
Okay.
It doesn't require that they not be. It simply requires this to be taken into consideration.
And as you all know, some of the delegates had to leave for a meeting, so this is to the committee and to the audience. If anybody has any difficulty with these bills, we'll take them by for the day. If not, I thought it worthwhile to present them, and if you're so inclined, we'll report them. Is there anybody in the audience who wants to speak to this, typically in opposition? Is there a motion?
Chairman.
Oh, I'm sorry, House Bill 359.
Mr. Chairman.
Senator Chafin.
Does this bill seek to create a presumption that it's better to be bitten by a police dog than another dog?
Yes.
It depends on how you look at it, Senator Chafin.
Just there again.
It's better if you're the biting dog to be a police dog.
Is there a waiver involved?
The dog's mother.
You know, Senator Peterson and Senator Obenshain, I don't know why you hate little children that ride horses. I just don't understand that. All right, is there a motion on the bill? Motion properly seconded to report the bill. All in favor, please say aye. Aye. No noes. Unanimous.
Mr. Chairman.
Do we have any bills left?
I have one.
Oh, Senator Stanley.
Mr. Chairman, members of the committee, on behalf of Delegate James Edmonds, House Bill 564. It's a real killer. The purposes of this bill is twofold. The first is to clarify that the requirement to use blaze pink, if you all remember, we passed now blaze pink in addition to blaze orange can be used when hunting. It now modifies and clarifies that the requirement to use blaze pink or blaze orange must be safety pink or fluorescent pink and not, I repeat, not pink camo.
Damn, I just brought that out.
I know, sorry to break your hearts. Second part of the bill requires the use of blaze pink or blaze orange be used on ground blinds when otherwise required for deer hunting. Third thing is that if you're riding a horse in this area, you have to have a waiver for the blaze pink. Signed by your parent.
Is there a motion to PBI? I will tell you that you either have to vote yes on this or everybody has to vote no, because I'm not explaining this on the floor of the Senate. Anybody in opposition to this? Motion properly supported to report the bill. All in favor, please say aye. Aye. That's unanimous. Before the committee
Mr. I
leaves.
have House Bill 853.
Senator McClung, just because I'm going to forget if I don't do it. On House Bill 286, it was Delegate Bell's bill letting dogs into wineries and breweries. We need to reconsider that and re-refer it to Finance, and we missed it. trying to move so fast? Because the chairman of Senate Finance said it has to be re-referred up there. So can I get a motion to reconsider? Senator Stanley moves, Senator Dance seconds. All in favor, please say aye. Aye. Senator Stanley moves that the bill be reported and re-referred to Senate Finance. Senator Dance seconds. All in favor, please say aye. Aye. Opposed, no. The ayes have it. And Senator McClellan.
Thank you. On behalf of Delegate Peace, I have House Bill 853.
853.
This one establishes an exemption for tribal communities that are recognized by the Commonwealth from being required to obtain a saltwater fishing license. This basically just conforms freshwater and saltwater fishing license exemptions for all of the Virginia Commonwealth recognized Indian tribes.
Did that already? Don't we already do that? No?
We do it for freshwater. We don't do it for saltwater. So this adds saltwater.
All right. Any questions of the surrogate patron? Is there anybody who is in
They've been
opposition?
fishing longer than you guys.
Opposition to this? Not. Is there a motion on House Bill 853? Motion properly seconded to report the bill. All in, wait a second. You would have thought that had to go to finance, but it does not. I mean, just make sure. No? Motion properly seconded to report the bill. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Chad, can you tell us, do we have any other bills, or did we get through the docket? Which one? Delegate Stolley. Delegate Stolley, House Bill 346. And what, as I read House Bill 346, what this does is it allows any locality to adopt an ordinance that prohibits the operation of a personal watercraft, a jet ski, on a public lake that measures less than 50 acres in extent. I'm not exactly sure what that means, but that's the gist of the bill. Did you want to speak to that?
Just Angie Bezick on behalf of the City of Virginia Beach. We support this bill. We did have a situation in which a gentleman was operating a business on a smaller lake, and it eventually went to court and was ruled in our favor, and we just thought in order to save localities and folks who are on the lakes,
Is this a Virginia Beach specific issue?
I don't know if it's Virginia Beach specific, but it was a specific incident that we had, and we're trying to cure that so that we're not having to go to court each time somebody's on one. We have lots of little small lakes that people are acting dangerously.
I sense some concern, kind of like on waivers for little children with horses. We might want to let this. We might want to let this go over.
Move to carry it over till the next meeting.
Next week, thank you.
Yeah, and take it up when Delegate Stolley can be here. Thank you. I believe that's the docket. Thank you all, and the committee will rise.